So welcome back, Paul. Welcome back to all of you on the Thursday evening. Welcome to LIRA in Law. I'm your host, Lyra of Douglas Simon Solicitors. We're a firm in the United Kingdom, in London, Greater London, in Richmond. And thank you very much for joining me, on the Thursday, rainy evening. And I hope you're getting ready for Christmas. And I hope you have a few days break. It's nice to actually just be able to kind of chill over the at least a few days now over the Christmas period. So I have not done any of my shopping, not even one. Okay? So I hope that you're not as bad as me. Anyway, so without further ado, we're going to launch into our topic. Ang topic po natin as I say, is divorce and an uncooperative spouse. And thank you very much for the viewer who sent this question. So let me just unpack the question So she's processing her divorce in the United Kingdom. Now, sabi nga niya, I got married in the Philippines, okay, kinasal nga siya sa Pilipinas, but have never been to the UK. So I think that may be slight error nga, no? So it could be na yung asawa niya, nandito siya, pa yung asawa niya, nasa Pilipinas, I would imagine. So she may have meant nga, but that her husband has never been to the United Kingdom. So yung asawa niya na, kinasal sila sa Pilipinas, dito nga siya, yung asawa niya nasa sa Pilipinas pa rin, hindi pa siya napupunta sa United Kingdom ever, no? We've not had contact for almost 7 years. Okay? This August, I reached out to my husband to begin the divorce process, but he refused to cooperate. It happens. Yung niya, sabi niya, now I'm facing difficulties with this form called D11 and D13B. They're very confusing forms. What are the possible things that I can do? So ang topic po natin, as I say, is divorce and an uncooperative spouse. So yun. So ang problema nga, kinasal sila sa atin. So valid ba yung kasal nila sa atin? The answer is yes. No? Then she wants to obtain the divorce in the United Kingdom. Is that possible? The answer is yes, more likely than not. But I'll touch I'll touch on that issue a little bit more. And if she petitions for divorce nga in the United Kingdom, she applies for divorce in the United Kingdom, and he won't cooperate, anong kailangan niyang gawin? So yung pag-uusapan po natin. Now, unang-una, yeah, tama kayo. Kung nasa Pilipinas nga kayo, there's no divorce in the Philippines. That remains to be the case. I know that only second time I think it's second time in history actually. There's a bill, that's gone up, and hopefully nga it's considered. But there's a bill going up that may allow divorce nga in the Philippines. But at the moment, wala po. So kung nandun ka sa Pilipinas, there's no divorce. There's judicial separation, for example, other things potentially nga, but not divorce in the same way as the United Kingdom. Pero kung nandito kayo, so sabihin natin, doon kayo kinasal sa atin, you left the Philippines to come into the United Kingdom, and in the United Kingdom, you are then, let's say you are working, dito na kayo nakatira. Matagal na nga kayo dito. In our viewers case, no contact for almost 7 years. Siguro nandito siya for at least 7 years, maybe even longer than that nga. Now, she wants now to petition for divorce dahil matagal na nga silang wala, and maybe she also wants to start remarry, for example, have a relationship with someone else. At saka yung asawa niya na nasa Pilipinas, it could be that he also wants to end the marriage nga formally. Now, pag-uusapan po natin United Kingdom, of course. So, unang-una nga, o pangalawa, so is the marriage valid nga in the Philippines, even though nandito nga kayo? The answer is yes, because the marriage would have followed the marriage requirements nga to make it a formal marriage, and that would be recognized by United Kingdom. Yun ang una. Now, nandito siya, and can she then petition for divorce even though doon kayo kinasal sa atin at saka yung asawa niya nandoon pa? Now, yes is the answer if the court here has what's called jurisdiction. Now, can they look at the divorce that where the marriage has taken place in the Philippines at saka nandun pa rin yung respondent nga? The answer is they can if you are habitually resident or indeed domiciled in the United Kingdom. No? Now, kung yun, ang sitwasyon, nandito ka nga, then yes, you can petition for divorce. Now, so inumpisa mo na sigurong proseso, no? So you petition for divorce, likely that was done online. Most petitions now will be done online. If you have representatives, it must be done online. If you're acting in person, then you have the possibility of paper divorce nga, but most of the time it's frankly easier to issue divorce proceedings nga online. But that just means it's computerized rather than getting the paper, completing the paper, and then paperwork and then sending that off. It's faster to do it nga online. Of course, to do that online, kailangan mo ng email dun sa asawa mo. Now, so you got so far as making the application. So nagpasok ka na ng application for divorce. Now, in August, tinawag mo siguro siya, sabi mo, okay, inumpisan ko na to, can you sign the documents when the court sends it to you? Yun siguro ang sinabi mo sa kanya, no? So ang sagot niya sa'yo, no, hindi ako papayag. O sabi mo dito, but he refused to cooperate. O maybe sabi niya, well, tingnan ko. Tapos wala naman siyang ginagawa, no? To continue with the petition, to continue nga with the divorce, then you need to ask the court for permission, essentially, no, to be able to continue. Kahit hindi nga pa siya, hindi siya gumagalaw. No? Anong kailangan mong gawin? So the formal process is this form called D11 or D13B. Now, the two are quite different. Papakita ko sa inyo ang itsura, okay? Let me just see if I can find nga the D11, which is the applications. Yeah, yan ang itsura. It's a few pages, so let me scroll down. Tingnan mo. So at the very top, makikita yung application notice, okay? Let me just see if I can scroll down, makita niyo yung ibang pages, no? So it goes on. I mean, it's not so long. I mean, frankly, I've seen far longer forms, no? So itong itsura. It's a few pages long, goes on. So then, of course, you have the usual section where you need to sign, yung address nyo nga, no, how you contacted, ganon. There's a court fee. I think it's £50 still. That's the court fee. So hindi naman ganong mahaba. As I say, I've seen far longer documents in family proceedings nga. Now, that is called a D11. It's an application, basically. No, it's an application form. Yun ang kailangan mo for what's called deemed service. Now, let me just explain that a little bit more. Kung alam mo kung nasaan siya, kinontak mo nga siya, sabi niya, hindi ako sasagot, o I don't want anything to do with this nga. Pero nakuha na nga niya yung petition. Ayaw nga lang niyang sumagot, no? But you served the documents on him already. He's just being difficult for whatever reason. Then ang kailangan mong ipasok itong D11. That's application. Ang application po is what's called application for deemed service. And it means exactly that. So, you're saying to the court, nakuha na niya yung dokumento, no? And so I want to be able to continue. So please, court, can you make an order that he has been deemed to have been served? Nakuha na niya, no? Yun. So that's a deemed service application. That's what you're asking for, an order for deemed service. Now, anong kailangan nyo idagdag? Hindi lang yung form ang kailangan nyo ipasok. Not just the D11. You need also a statement in support of the application. The application nga lang yun, ano? So that's documents in support. So, sabihin natin, this is something, tip ko, no? Kung alam nyo kung nasaan nga siya, so alam nyo hindi siya papayag, let's say, it's still worthwhile making contact with them, at least by email or by phone even. Okay? So kung nagtawagan nga kayo, tinawagan mo siya, so sabi mo sa kanya, gusto inumpisan ko na to. Pagka nakuha mo yung dokumento, pwede ba na sagutin mo yung korte? No? Kung sabihin niya sa'yo, hindi ako sasagot. Bakit pa ako sasagot? Wala akong pakialam, no? Tapos binaba yung telepono sa inyo. Make a note, tip ko make a note of the time, the date, okay, and what was said. Dahil ito pagka nagpasok ka ng application for deemed service, kailangan mong ebidensya na talagang nakuha na nga niya. So yung statement mo, sasabihin mo doon on so-and-so date, so anong petsa na nga yun? 12th, no? 12th of December. On the 12th of December, 2024, I telephoned the respondent. I advised him that I've issued petition, an application for divorce, and to warn him that this will be emailed by the court, and if he would consider it, and if he's in agreement to sign it. In reply, the respondent said that even if I received this document, or I've received the document, could even be, no, even better, no? I've received the document, I'm not going to agree to this. I have nothing to do with this. You can go to, sometimes they do that, no? Then, ilagay nyo din yun sa statement, no? So, and then end with, clearly, the above means that he received my petition for divorce, but he's simply choosing not to cooperate for reasons known to him. Now, kung pwede, dagdagan nyo pa, no? Anything else that, so for example nga, sabihin natin nakatira siya sa nanay o tatay niya, no? And silang sumagot ng una, no? And then they say to you, oh yeah, no, sabi nga nung, sabi niya nasa kanya na, papasa ko yung telepono sa kanya. Kung yun, also add that, no? It was confirmed to me that the documents were in fact my petition for, my application for divorce was in fact received, not only by the respondent himself, but also by his mother who initially picked up the phone, for example, okay? O kung nag-email nga kayo, no? So so you may have emailed him to say, oh, did you actually receive the petition for divorce? When you send your email, alam niyo kung nagpapadala, especially those of you like me, no, we send a lot of emails nga. It's not conclusive evidence, but it is again indicative that he's received it. Alam niyo, you can tick the box that says no, read receipt, okay, or delivered receipt. Yeah, you can tick both boxes, and then you can also send that to the court. Makikita nila, okay, on so-and-so date, binuksan niya yung email, and he even read the email. Yun, okay? Or, even better, kung sumagot siya sa'yo, sabihin natin nag-email ka, sumagot siya, sabi niya, go away, or something, words to that effect, no? You can even include that. So yung application for deemed service or using the application form D11 is to really say to the court, can I proceed anyway? Then nakuha niya. Please make an order that he has received, he's deemed to have received the petition. No? And this is my statement nga in support, and any documents again in support. Hindi nga to basta-basta. The court would want to be satisfied na talagang pinadala nga siya. No? And where the court has sent it rather than you can also send, I was informed by the court that the document were sent to him by email on so-and-so date. No? So it's for you to prove na talagang nakuha nga niya. Kung nakuha niya, so pinadala nyo, nakuha nga niya, or likelihood is nakuha nga niya, then the application, ang kailangan mong kumpletuhin is the Form D11, but you need to add to that statement nga in support, okay? And any documents also supporting the fact that you say na nakuha nga niya, is more likely than not that he has been served. So he's just being uncooperative. No? Yun. So that's the Form D11 now. Now, sometimes, so looking at the question nga again, no, sabi mo nga dito, we've had no contact for almost 7 years. If that's the case, actually just no contact nga, hindi mo alam kung nasan siya, hindi mo din alam kung buhay pa nga siya, wala ka ng contact nga sa mga kaibigan nyo dati, o kaibigan niya, o mga magulang niya, no, kamag-anak nga niyan sa atin, then it's more likely that the form you need to complete, the application you need to complete is the Form D13. Yun. So it's an application to dispense with service. So ibig sabihin, there's no point, sinasabi niyo sa korte, there's no point submitting this, serving him because I can't find him. No? That is a harder application actually than the application for deemed service, because you're saying to the court, I want to proceed even though he's not been served. Because I want to dispense with service. So I just don't know where he is. More likely than not, the court will want to know what efforts have you made. No? Why have you not made any? Have you made contact with any of his family, for example? No? have you made contact with any friends? Okay, have you tried writing out to his last known address? If he went abroad, you have those details now. So that is a harder application because you're essentially saying to the court, there's no point even trying because we've I don't have any details for him, so I want to dispense with service. Okay, yun ang application. So the document you then need to submit is the other form. So let me just see if I can bring that form up to D13. Sandali ito. Yeah, ito po, no? So makikita nyo sa taas, statement in support of request to dispense with service of the divorce, okay, amongst the things on the respondent. Mahaba nga din to, and there's some useful guidelines actually on the right-hand side nga, some notes. Kailangan basahin yun, So you'll see it's quite long, and it's asking for where was the last known address nga niya, and any maintenance order, enforce all of those. So it's a bit more involved though. So, and there's a statement of truth. And for both documents nga, and any applications nga to the court, you are be careful, no? Dahil nga, if there's a statement of truth, and ibig sabihin, you're saying that whatever it is that you've signed, you've submitted nga are true, no? And if it's not true, then you can be prosecuted for that. And never mind also the application will not go through, but if you've lied to the court, that of course it can be a criminal offense, no? So importante nga yun that you only submit documents that are of course correct, and any statement you make would be also honestly made, no? So if you have no contact nga with him, hindi mo nga alam kung buhay pa siya o hindi, then the application would be to dispense with service. So there's no point, hindi mo alam, no? Okay, but as I say, that's a harder application. But our reviewer, I think it's more likely than not that it's a D11, yun ang kailangan mong ipasok. But don't forget, kailangan hindi nga lang yung papasok mo, you need to submit also documents in support, mainly nga statement. You say what efforts have you made, no? To prove that indeed he received the documents. He's just being silly. He's being uncooperative, not necessarily silly, but he's being uncooperative nga. And if the court is then, you need to, if you've done it remotely, then you also need to upload that. When you've uploaded that, the court will then reply whether or not your application has been granted. Sometimes they say, not granted, we want you to make further efforts. And sometimes they make comments, try posting it, I've also had cases where the court have said, well, have you tried newspapers? No, I mean, posting notice on a local newspaper na yung nga, no, that this petition. So that happens less nowadays. But so yun, it's I think sa'yo yung our viewer nga, it's probably more likely the D11. Now, going back a little bit to question yung comment nga niya, no, sabi niya, I got married in the Philippines but have never been to the United Kingdom. That is a problem if I read it right, no? I think that's you probably mean, at least I hope nga, na nandito ka, so yung asawa mo has never been in the United Kingdom. But if you have never been to the United Kingdom, even though you may have some links here, no, then the court is unlikely to have any jurisdiction. So ibig sabihin, they can't deal with your divorce in the UK because you are neither probably habitually resident or domiciled in the United Kingdom. Okay, but I think that's probably just a typo. I think ibig mo siguro sabihin yung asawa mo, he's never been in the United Kingdom, and that happens sometimes. Actually, not just sometimes. I see that often na kinasal nga kayo sa Pilipinas, for whatever reason, hindi niyo siya makuha, hindi niyo siya kinuha nga dito, and then you always therefore live pretty much separately most of the time, no? And in this case, of course, 7 years minimum that you've been separated. I suspect it's probably longer nga than that. So to sum up nga, it's more likely than not na kailangan mo ipasok is the to complete is the form D11. That's application for deemed service with statement in support, with documents in support to show the court, to convince the court that indeed he has been more likely than not served with the documents. Yung nga lang, he's being uncooperative. Now, let's say you did that. No, naipasok nyo, and the court says, yeah, okay, no, we believe that he probably received the documents, and therefore now we're going to you can have your order. No, so an order for deemed service has been granted, or an order to dispense with service has been granted. What then happens? Then and only then can you take the next step, which is an application then for a conditional order. In the olden days, well, not so old, that's in pre-2022, it was called Decree 99. Ngayon, tawag nga conditional order. They're practically the same, really. Now and then after that, once you've had your conditional order, then you can apply for what's called a final order. When you have the final order, otherwise known previously as Decree Absolute, then and only then, can you remarry. You should not remarry before then, because if you do, then and you're still married, then that marriage is likely, the second marriage is likely to be void, but more likely than not. And then on top of that, it could be a criminal offense. Okay, so do not remarry before you get your final order. It doesn't matter. Now, I've heard people also say, well, I got it the following week naman eh. No, doesn't matter. You must not remarry before you get the final order. The date on the final order is the date that you are free to remarry. Okay, so you're on. So I'm sorry if you're having this problem. It can be really confusing and sometimes depressing, especially now if you want to get on, with your life and you want to remarry in the UK. It can get a bit complex, and the courts, as I say, you have to convince them that it's a proper order to be made. So you need to make your case that indeed he's received it, or you need to apply enough to dispense with service because for whatever reason you can't get hold of him anymore, and he's not maybe he's not even alive anymore, but nevertheless you're not sure. If you get a divorce in the United Kingdom, if you get a divorce in the United Kingdom and you follow the proper procedure, nandito ka nga, then of course that divorce will be valid in the United Kingdom and frankly valid everywhere else, but not the Philippines. Okay, in the Philippines there's no divorce, and Philippine law of course applies. So which means that sa atin, in order for that to be recognized, sometimes people can make an application for that decree to be recognized, recognition of decree nga. Or sometimes you need to issue annulment proceedings, which I know can be very long, lengthy process and also quite expensive. So if you have a way of using the divorce law in the United Kingdom, that's probably a better bet. And anyway, kung dito kayo nakatira, then really this is the proper jurisdiction. So you're on. So hopefully that's of help to you. It's one of those one of those processes within divorce proceedings that can be a bit confusing and can be daunting, as I say. But hopefully that's helpful to you. And as I say, the form, there's also a kind of guidance that you can read. But sometimes it just gets so confusing. But look, you can also get advice, of course, on the forms themselves from a solicitor. Kung hindi nga kayo, if you're not sure, okay. So you're on. But look, good luck. Hopefully you get that, because especially Christmas is a funny time for divorce proceedings often. Dahil mga tao nga sometimes they say, okay, next year, next year, may gagawin ako next year in relation to an unfortunate breakdown of relationship, or sometimes they want to do it now, so the next year, tapos na, so they have a fresh start. So it can go both ways nga, but it's a difficult. It's not necessarily difficult process, but the things that go with it can be quite difficult. And also for a lot, it's painful. So look, good luck. Hopefully that's helpful to you. And as I say, in your case, I think it's the D11, rather than the other document. But don't forget, kailangan statement, okay? Take statement. So and you have to prove to the court that your efforts are these. Okay. Now, so I hope that you found our topic now interesting, and it's one of those areas of law, as I say, that can be quite confusing. Now, we have other questions, many other questions now. But before that, let's read our greetings. No, batian tayo. And I say this all the time because it's true. It's my favorite part of the show. So, kung nanonood kayo and you're thinking, maybe kakamustahin ko siya o hindi kaya, kamustahin niyo ako. A quick hello, right?